Now back to the show. This is The Law Show on CL 650.
And welcome back to The Law Show on CL 650. Gordon Maynard and Alex Stojkovic join me from Maynard, Kisher, Stojkovic, MKS in downtown Vancouver, immigration lawyers, and we're having a great discussion about permanent residents who can be deported if they're convicted of a crime over 6 months, is what you're saying, right?
Yes. So I have an example here of how the system should work and how it did work in the case of one person, and really where I don't really have. And I don't think most of us in the bar we don't like the outcome particularly, because many philosophically, like myself, and I think I speak for Gordon also, don't like the idea that anyone who's been a long-term permanent resident, especially who was a permanent resident when they were a youth, since their own youth, they could be deported to a country that they've never been to. But in this particular case, I had a client who had 20 convictions over the course of most of his life, like from young adulthood all the way into...
What sort of stuff?
Well, all kinds of things, mostly bar fights,
okay.
In work camps up in northern Alberta and northern BC, where he worked. This is a fellow whose parents eventually became citizens, who immigrated from the UK many, many years ago, and whose siblings are all now Canadian citizens, and who nobody realized was not a citizen. He himself didn't realize he was a citizen until he was eventually reported after one of these many, many offenses.
Because everybody in his family is a Canadian citizen.
He
just thought he was.
He figured he was. He never turned his mind to this. And most people around him assumed he was a Canadian citizen because he has no accent. He lived amongst other people who were Canadian and in areas where there aren't a lot of immigrants, particularly in Canada. And so everyone assumed he was a citizen also. Which goes to show you these things with labels are a dangerous thing. Who amongst us is a permanent resident? Who amongst us is a citizen? Well, when they determined that he was a permanent resident, then they reported him for his various criminal offenses. And he was reported, and he went to an appeal. And at the appeal, they reviewed all of the circumstances of his case. And in that review, they came down with, they could have allowed him to win his appeal, or they could have sustained the initial removal order and had him deported. Instead, they came down in the middle, and they put on what's called a stay of his removal. And the stay was predicated on, look, if you're a good boy and you do the following things for the next X number of years, they could do 6 months, they could do 4 years, and you abide by all of these conditions, keep the peace of good behavior, don't be convicted of any more offenses, you can stay, given how long you've been here. So the benefit of the appeal to him was he got that last chance. Okay? We understand you've been here a long time. We're not going to apply the law mechanically to you. If you screw up again, you're gone.
Mm-hmm.
Okay?
That seems like a common sense approach.
That's a common sense approach. And I'm far happier with that, and I think most of us in the bar are far happier with that type of review than no review of that sort. And what the minister under the previous government called the Faster Removal of Foreign Criminals Act was taking that review away. So this is what's wrong.
How did he get it? Was this before that?
No, he didn't commit anything serious enough on its own that got him a 6-month jail term.
So he
No, they admitted the 2-year rule at that time.
It was the 2-year rule at that time, yes.
Right.
So he didn't get anything that got him 2 years in jail.
So had it had been today,
maybe he would have lost it.
Maybe he would have lost it the first time.
Because today the rule is 6 months.
Right. No hearing.
No appeal, no review of your circumstances.
There is a hearing, and that's called an admissibility hearing, but this hearing is merely to go over the criminal documents and confirm that the person has been...
your name is Bob, you're a permanent resident,
right.
That's your conviction, here's your removal order.
If it's an offense in Canada.
So someone has, had a, what would you call it, a 6-month...
Conditional sentence order.
Conditional sentence. And they can just be fast-tracked out of the country.
Yep.
So is this going to change as we have a new government? Every time I see you gentlemen, there seems to be change afoot because of a new government. This sounds like the Conservatives'
this isn't on their
law
agenda
and order
yet.
agenda?
This is not on their agenda yet, no.
Yeah. So,
however, we understand that there is a case coming up at the Supreme Court of Canada in January of 2017.
That's right.
And it involves a permanent resident who was given a conditional sentence order 6 months or more and lost his right of appeal based on that. And the issue is this a sentence of incarceration for the purposes of taking away rights of appeal under the Immigration
Oh,
Act.
so they're arguing that they were given the 6 months to get them out of the country.
Well, no, what they're arguing is the 6 months was the 6-month sentence, or more than 6 months sentence, the conditional sentence order, was intended to be a light sentence, intended to be a sentence for people who don't deserve to go to jail. So what typically happens is if you're a bad guy, the criminal court judge says, I'm going to send you to jail for 3 months. If you're not such a bad guy, the judge says, you know what, I'm going to give you a conditional sentence of incarceration.
Which you serve in the community.
You serve in the community, you're allowed to go to home, you're allowed to go to work, you're allowed to go to school, you have a curfew.
It's almost like a house
But
arrest kind of
typically,
situation.
it is a house arrest.
Yeah.
But typically, if they were going to give you 3 months in jail and they change it to a conditional sentence order, they make it a 6 or 9 month conditional sentence order. It's typically longer than what you would have had in jail.
So
it's
if you had
intended
gone
to
to
be
jail for 3 months, you would have been better off.
you would have been
That's
fine.
right. Or even
Yeah.
5 months, you would have been better off.
Yeah.
And some people have gone back and appealed their original sentences so that they go to jail for 5 months because they get to stay in Canada.
No,
And
they get to have an appeal.
They get to have an appeal, sorry. They get to have an appeal, and they avoid this process, at least the fast tracking of it. So it's
Fascinating.
perverse. I mean, in some
who would have
respects.
known? I mean,
Well,
I'm sure there's a lot of
It's the
permanent
way-
residents have no idea about it.
That's right.
Absolutely.
And,
Because, look,
and
I
to
mean-
suggest that Parliament knew this is what they were enacting when they made the law is ridiculous.
Ridiculous. They had
There's no
idea.
way parliamentarians knew that this was the way the law was going to be used.
Well, they were doing what they thought was right by getting bad guys out of the country. That's really
Yes.
what they tried to do. But
Right.
they didn't have a process to make sure that they weren't just throwing the baby out with the bathwater, right?
Well,
Right.
that's it. And look, in terms of these people that are being kicked out, we're kicking out people to countries that they've never been to, where those countries now have to take them back in. We're creating all these issues with those countries who are asking, why is this person coming back, or what's going on with this, and why are you not allowed to keep him there, and isn't this a product of your justice system and your social system? Aren't they really your problem, Canada? And these are some of the challenges that that are around this particular area.
So
And I want to make a point here too.
Mhm.
And I say that this is my opinion, and I stand by it. That when the government changed this from a 2-year rule to a 6-month rule, they misrepresented to the Canadian public what the effect and the purpose of this legislation was. They misrepresented it. They miscast prior cases where they claimed that permanent residents had abused the system. That's simply not true. The system worked very well. What happened before was that the government screwed up in some cases, where people subsequently committed criminal offenses before they were removed from Canada, not because they had a right of appeal, because the government screwed up and didn't remove them when they had the authority to do so.
So you have this 20,000 plus number of people that are being sent out of the country. Of those 20,000 people, how many do you think fall into this sort of no man's land versus true bad guys that should be sent out of the country?
One
Well-
is too many.
You think one's too many?
There are hundreds of these cases a year. There's probably over 1,000. And I'll tell you, because the issue here is once the law is changed, it's the low-lying fruit that gets picked first.
Mhm.
Yep.
And, you know, when this first incarnation of these laws happened in the 90s, both Gordon and I were practicing. And back then, you lost your appeal right if you were a quote-unquote danger to the public. And this was the Liberal government changed the law at the time to deal with a case, the Not Just Desserts shooting, where one of the 3 shooters was turned out to be one of the 3 people involved in the robbery, where the woman was killed in that dessert parlor in dessert cafe in Toronto, as part of this botched robbery, was a permanent resident who had had a stay of his removal. Somebody had, said, okay, it's been a long time since you were in Jamaica. We're going to give you a stay if you keep your nose clean for a year. The shooter was a Canadian citizen, but one of the other 2 was a permanent resident who was under a stay of his earlier deportation order. And so the law was changed that if you were a danger to the public, you lost this right. So the government has always tried to use this kind of legislation for the past 20 years to give themselves the ability to remove people to avoid embarrassment, or being embarrassed by cases like this. Because unfortunately the media in Canada has had a tendency to attack the government over this type of individualized
It's a natural
case.
reaction, right?
Yeah, natural reaction perhaps, but and so to deal with it, they want to maintain that they have all of these authorities and powers to do so, and they justify it by saying that they're protecting the Canadian public, when really they're protecting themselves from embarrassment, is how I would argue. I mean, the reality is that you need a process to review these things that's impartial. And if after an impartial process you determine that the person is a danger to the Canadian public and that their danger outweighs the connections they have to the country, well, fair enough. But if there is no review of that, what you're then doing is you're creating a situation where we treat people completely differently purely on the basis of whether or not they've put in for a citizenship test or not.
Mm-hmm.
Yeah. Common sense should rule the day.
And I should say this, it's not so easy. I mean, the Conservatives also, when we started in this area, both Gordon and I, citizenship didn't cost you anything. There was a nominal fee of $5 or $10. Today, if you apply for citizenship, it's $630. So if you're talking about a family that's on a fixed income, and they apply for their family of four to apply for citizenship, we've talked about this on other shows, $1,260. This isn't a legal fee. This is what you have to pay them. It's $1,260 for you and your spouse, and then for your two children, another couple $100. You're spending $1,700 to apply for citizenship. Not everyone has this.
So would it be good advice to say if you're a permanent resident, don't stay a permanent resident forever? You should be better off to become a Canadian citizen?
Of course.
And I know people who are permanent residents for decades.
My father was a permanent resident in Canada from the time he was 6 months old when he came to this country until he was 65 years old. He thought he was a Canadian citizen.
Right. And I'm sure there's quite a few people that fall under.
There are many, many people like that, and that's who's been caught by this.
And they must only find out when they go to get documents?
When they apply for their pension, when they are asked today in today's modern regime compared to say 20, 25 years ago, you weren't asked to produce 20 pieces of paper for every and 20 primary identity documents for everything, like old age security, like Canada pension, like to even get your passport. With the rules in place now, you really have to produce something that says you're a Canadian citizen. And if you can't, then now you have a problem you've got to deal with.
All right. So
on the other hand, there have been changes to the law, like the permanent resident card, which was introduced in 2002 law, but really came into force in 2004 or so. That's a card that says you're a permanent resident, but it expires every 5 years, and you have to renew it. Now, for that reason, people are now reminded that they're permanent residents.
And
so we're probably going to see fewer of these cases down the road, but nevertheless, you still get these situations.
We're going to continue our conversation. I can believe it or not, we started talking about the border. And we went down this fascinating avenue of permanent residents, and I guess ultimately is a border issue. But we'll pick it up with family class, misrepresenting yourself at the border when we continue next on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.